Start. Under Section 40 of the Act, previous judgments are admissible in support of a plea of res judicata in civil cases or of autrefois acquit or autrefois convict in criminal cases. Stop. Judgments such as those the relevancy whereof we have been called upon to determine do not fall under this category. Stop. Para. Nor can they fall under Section 41 of the Act, which only makes a final judgment of a competent court in the exercise of probate, matrimonial, admiralty, or insolvency jurisdiction, conferring upon, taking away from, or declaring any person to be entitled to any legal character or to be entitled to any specific thing absolutely relevant when the existence of any such legal character or the title of any such thing is relevant. Stop. They do not also fall within the purview of Section 42 of the Act, as they do not relate to matters of a public nature. Stop. Section 43 of the Act positively declares judgments other than those mentioned in sections 40, 41 and 42 to be irrelevant unless their existence is a fact in issue or is relevant under some other provision of the Act. Stop. It is quite clear that the mere existence of a judgment in the present case is not relevant. Stop. Learned counsel for the petitioner saw this difficulty and wished to rely on Section 11 of the Act. Stop. Para. This section only refers to certain facts which are either themselves inconsistent with or make the existence or non-existence of the fact in issue or a relevant fact highly probable or improbable and has no reference to opinions of certain persons in regard to those facts. Stop. It does not make such opinions to be relevant, and judgments, after all of whatever authority, are nothing but opinion as to the existence or non-existence of certain facts. Stop. These opinions cannot be regarded to be such facts as would fall within the meaning of Section 11 of the Act unless the existence of these opinions is a fact in issue or a relevant fact, which is of course a different matter. Stop. Para. There is no reason in my judgment as to why the decision of the civil court, particularly in an action in personam, should be allowed to have that sanctity. Stop. There appears to be no sound reason for that view. Stop. Para. To hold that when a party has been able to satisfy a civil court as to the justice of his claim and has in the result succeeded in obtaining a decree which is final and binding upon the parties, it would not be open to criminal courts to go behind the findings of the civil court is to place the latter without any valid reasons in a much higher position than what it actually occupies in the system of administration of this country, and also to make it master not only of cases which it is called upon to adjudicate, but also of cases which it is not called upon to determine and over which it has really no control. Stop. The fact that the issues in the two cases, although based on the same facts, are not identical and there appears to be no sufficient reason for delaying the proceedings in a criminal court which, unhampered by the civil court, is fully competent to decide the questions that arise before it and for its decision, and where in the nature of things there must be a speedy disposal. Stop.